Zacarias Moussaoui, the so-called 20th hijacker, denying in court this week that he had any connection to the September 11th attacks against the World Trade Center. Moussaoui, appearing before a U.S. district judge, argued successfully to be able to represent himself in a trial later this year. He claims the lawyers assigned to defend him are part of a conspiracy to kill him. But will he be able to receive a fair trial acting as his own lawyer? With us today is former federal prosecutor Lise Wheel and criminal defense attorney Geoffrey Nathan. Thanks, both of you, for joining us today. We've all heard that a person who acts as a lawyer representing himself has a fool for a client. But if Zacarias Moussaoui wants to go that route, should we care?
He has an absolutely.
Okay. Well, let's go to Nathan first, because he's a defense attorney. Would you ever let, obviously you wouldn't let a guy defend himself.
I certainly wouldn't want to. I think what the judge did in this circumstance is made a two-prong analysis. One, that she feels he's competent to waive counsel, and two, that he's competent to proceed as his own lawyer. But what he's not going to be able to do is put out a case in chief. He wants to make a statement and turn this trial into a circus. It's not going to work. The judge is going to cut him off.
Thank you, Mr. Nathan. Lise?
The judge will give him more leeway than she would the lawyers in the case, for example, because he's going to have to present a case, and he's not a lawyer, so she's going to give him a little bit more leeway. But I agree in the sense that he is out. The whole thing for him about this was to make a statement, to have that opening statement, that closing argument where he can just spit out a diatribe against the United States, and she won't allow that.
Well, how sane can he be if he's saying that his lawyers are trying to kill him?
Well, he can be competent and yet insane. Competent just means that he knows about what the charges are and that he can help in his own defense, and she found that that was true. But he still could be legally insane, though he won't be arguing that about himself, I'm sure.
Some people are concerned. Go ahead, Mr. Nathan.
Yes, I was going to say that we've recently had two circumstances in which we had high-profile pro se defendants. Congressman Traficant did a wonderful job at berating bureaucrats in Washington while trying his case himself, and he's about to go to jail. We have the Serbian dictator, Slobodan Milosevic, had approximately a four-day opening argument. I just don't think that Judge Brinkman is going to allow this defendant to do that in this particular matter.
But Geoffrey, certainly he had the right to do this, right? I mean, he has a right to represent himself.
The rule of court certainly is quite that you don't have to have a lawyer. However, this case has been certified as a complex case. The docket sheet has already almost 85 different filings. I think it is an enormous mistake for Zacarias Moussaoui in a case that involves highly circumstantial evidence. Bear in mind, to think that he can walk out of there a free man isn't going to happen. They're going to kill him.
But I think he realized he's not going to walk out of there a free man. He said that. He said, I'm not going to see the light of day. What he wants is a forum. And what the judges got to do is make sure that they have a fair trial, but also rein him in so that it doesn't turn into a circus.
But wouldn't he get that forum no matter what, whether he's got a lawyer defending him or not?
No, because the lawyer, if he had a lawyer defending him, the lawyer would be the one asking the questions of witnesses. The lawyer would be one giving the opening and closing statement, not Moussaoui. So,
and I think what Judge Brinkman made very clear when she spoke to the defendant was, are you really certain that you want to do this? Are you aware of the penalty? And in fact, Liz, you're right. He said, yeah, I really want to do this.
Right, and that means he's competent. He knows what the charges are. He knows that he's in a courtroom and that he's facing the death penalty.
All right, let me ask both
Liz,
of you. There's a lot of concern about intelligence information, whether this man acting as his own lawyer will get his hands on information that he might be able to decode and possibly pass on to other terrorists or alleged terrorists who are out there in the world right now looking to commit other crimes against the United States.
If he had a lawyer, the lawyer would serve as a buffer. In other words, the judge would turn more information over to the lawyer, maybe even some nationally secure information to the lawyer, knowing that the lawyer wouldn't turn it over to Moussaoui. Now that the lawyer isn't involved as a buffer, the judge is going to be much more careful about turning that information over. My concern really is that in a trial like this, we won't have cameras in the courtroom, but it will be reported what he says. And can he send out information? I mean, it sounds like sort of a spy novel, but I really believe this could be possible. Can he send out information in a decoded way that people can decode, his cohorts? That makes me quite nervous.
And the tenor of this trial has changed dramatically by this one decision.
Right.
It really has, and I think that what we're going to see is that Moussaoui simply is going to turn this into his attempt to convert everyone over to his religious beliefs, and again, I would only suggest that the judge is going to cut him right off.
Right. Geoffrey, don't you think, though, that's exactly the judge's job in this, is to cut him off as necessary?
Yes, what the evidence that can be admitted at a trial like this is only evidence which is relevant to show that there was a conspiracy. And her job as a gatekeeper is to make sure that only evidence that is relevant goes to the jury. I think she's going to do a remarkable job at that, given how tightly worded her opinion was in allowing him to proceed on a pro se basis.
And Geoffrey, just back to point one here. Let's say Zacharias Moussaoui is your client. He says, I'm going to represent myself. What do you say to him?
I would say, first and foremost, I want to talk to the psychiatrist first. In this particular instance, the psychiatrist was a court-appointed psychiatrist who only spent 2 hours with the defendant. I would urge the defendant to reconsider, and if he didn't want me as a lawyer, I'd help him find somebody who he was comfortable with, and Moussaoui is saying, I'm not even comfortable with the lawyer that my mom hired for me.
But Geoffrey, you know that the judge was put in a box on this because Moussaoui said, I am not going to speak to a psychiatrist. He would not speak to a court-appointed psychiatrist. So the judge did everything she could, which is send the psychiatrist out there, have the psychiatrist observe Moussaoui, speak to the jailers, look at the criminal or the medical records. I have had cases myself where people have been found competent on much less than that.
Lise Wheel, Geoffrey Nathan, thank you both very much for joining us. We've got to move on. Appreciate it very much.